My name is Gábor Halmai. I'm a professor of comparative constitutional law at the European University Institute. And I have also the pleasure to be the scientific director of one of the programs of the Center for Judicial Cooperation at EUI. So I have the privilege to chair this today's webinar. Before we start with the lectures, presentations, let me say a couple of words about the Center for Judicial Cooperation, which has been established at the European University Institute in 2011 as a research institution within the Robert Schuman Center, dealing mostly with judicial interaction, mostly on the field of fundamental rights, and enforcing and practicing actually judicial cooperation, collaboration, trainings among legal practitioners and academics. One of the activities of the center is organizing lectures like today's lecture. And we even have since 2015 a series of lectures of the center, again, for providing an opportunity for academics working on the field of the judiciary with judicial practitioners, judges, prosecutors, arbitrators, or attorneys. So this opportunity today is one of those interactions between legal practitioners and academics. And we have a joint team for today's lectures, which is judging fundamental rights. As I mentioned, the main focus of the center is judicial cooperation on the field of fundamental rights, implementation of the Charter of Fundamental Rights of the European Union. So this was the main reason we selected two presentations for today, presented by two excellent practitioners and academics, starting with two very prestigious practitioners, talking about special circumstances of judicial cooperation and judicial activity during the pandemic, which is a very, very hot topic as we speak. So the very first presentation of about 35 minutes will be about this topic, and the two presentators will be in the order of their presentations. Pier Paolo Gori, who is a judge at Corte di Cassazione, the Supreme Court, if you say, would say in Rome, in Italy. And his first part of the presentation will be followed by the presentation of Aniel Palatzin, who is a legal advisor to the Council of State of the Netherlands, and he is also a deputy judge in the district of Rotterdam court. So without further ado, let me give the floor to Judge Gori. The floor is yours.
Thank you, Gabor. And I thank so much the European University Institute, the Robert Schuman Center for Advanced Studies, and of course the Center for Judicial Cooperation for inviting me to take part to such an interesting discussion on judging fundamental rights in COVID-19 times. I would like to thank ERA, or Europäische Rechtsakademie, as well for authorizing the dissemination of the article already mentioned by Gabor, Fundamental Rights Under COVID-19, a European Perspective on Video Conferencing in Court. There is no need to repeat in details the content of the paper, available both on the ERA website and on the newsletter of European Rights issued on the 15th of March 2021, and I think available also in this platform today. The survey, however, relies on a paradigmatic experience in two countries, one from Northern, the other from Southern Europe, the Netherlands and Italy, with legal systems partially different, but where, in both cases, especially in criminal proceedings and in court hearings before the COVID-19 crisis, the digitalization of justice was far from being complete. In spring 2020, suddenly, emergency regulation aimed to prevent the paralysis of the judicial machine introduced a massive use of technology, and in particular, video conferencing in court proceedings. It's important to recognize that this was a trend established well before, as many national and European projects already existed in this field. However, the spread of the virus accelerated this phenomenon in a dramatic fashion, yet never seen. Before COVID-19 pandemic, video conferencing in court was already used in many European countries as a technical solution, but in specific situations. And the European Court of Human Rights found no violation of Article 6 of the Convention. For instance, this was the case of minors heard as witnesses in trials for sexual abuses, or persons detained in a prison regarding mafia, or other serious offenses that could already take advantage of such a technology. However, the exceptional measures adopted in spring 2020 to govern the health crisis introduced for the first time the idea of a possible full legal procedure being carried out through video conferencing instead of the physical standing court. Is this merely a quantitative, massive adoption of an already well-known item in the toolbox of lawyers and judges? Or can it, through its indiscriminate use, have a qualitative impact on the exercise of jurisdiction, especially at first instance where the core evidence is taken before a judge and the right to be heard is traditionally exercised by a defendant in a classic public hearing? Such a new approach to the judicial efficiency raises a number of questions regarding the compatibility of video conferencing in court with key fundamental rights, namely respect for privacy due to the specific commercial technology adopted, and more generally, with the right to be heard in court, the right of defense, the right to effective judicial remedies, and of course, the right to a fair trial. The paramount references to be taken into account among, of course, with national constitutions are at the European level, the Charter of Fundamental Rights, namely Article 47, and within the European Convention on Human Rights, especially Articles 5, 6, and 13. The research focuses on the different degrees of protection granted through a multi-level system, both at the national stage and at the European one, throughout possible preliminary references to the Court of Justice and effective execution of the case law of the European Court of Human Rights at the domestic level. In the last troubled year, 3 different chronological periods are recognizable. The first one encompasses almost all spring 2020, 10 days earlier in Italy, because it was the first Western country to be hit severely by the spread of the virus. At the time, many pending judicial proceedings were suspended until mid-May 2020, and only urgent files were discussed and decided, especially criminal cases. This is the case, for instance, of urgent criminal matters like trials of arrested persons, where the exercise of the police power of arrest needs, by law, to be validated within a few hours by a court. Well, the second span of time starts from mid-May to October 2020. The effects of the early traumatic national lockdowns and the subsequent decrease of the COVID-19 path of diffusion led many courts to underestimate the risk of a resurgence of the virus, and so to plan for many months to come almost only traditional hearings without video conferencing devices. More, several hearings were overcharged to try to cope with the increased backlog due to the previous lockdown and the subsequent delays of the proceedings. This attempt of restoration of the ancien regime was welcomed by many that never fully accepted the use of video conferencing in court as a normal tool, among others, of course, with the due respect of the preconditions outlined in the paper, of course, to grant effectiveness to the judicial action while protecting public health. However, it was brief illusion that at the end contributed to a considerable number of members of the registry, lawyers, judges affected by the virus, with further delays in hearings, where several actors of the interest proceedings tested positive to the COVID-19. And this, unfortunately, reactionary approach possibly contributed to the resurgence of the pandemic as well. As we well know, indeed, the war against the virus was not over, not yet. The third period, still ongoing, has seen many emergency measures from last spring to be revived and lead us to the point. We need to accept that the pandemic will have long-lasting effects, well beyond the end of the resurgence of the virus, on the judicial machinery and on technicalities of the court hearings, leading to a dramatic increase of the importance of technological devices in legal proceedings. Coming to the conclusions, our analysis suggests seeing video conferencing in court not as a value in itself, no, but as a modular protection, of course, an instrument both for the judiciary and for lawyers that could serve hearings under certain preconditions, and that can be used to carry out most, but not every, judicial activity. The proposed approach here, as a result of the survey, suggests distinguishing case by case 3 different scenarios. Hearing activities, first of all, that are well or even better performed through video conferencing, rather than in a conventional way. Secondly, activities that can be carried out using such tool, but at some cost of certain complications which must be carefully assessed. And thirdly, activities that are impossible or hardly compatible with video conferencing. The use of video conferencing, at least for the first category, deserves to be preserved even when, we hope soon, the health crisis will be over. As an example of the first option, video conferencing could grant exhaustive protection of the right of defense as a means of reducing the discomfort caused by journey of a detainee, for instance, in temporary custody, to reach the appointed judge for his submissions. Best practices already established in courts favor the adoption of video conferencing as much as possible with the parties' agreement rather than by means of a court order. That's why, at least in civil and administrative matters, where there is a strong interest for most parties to get through hearings quickly, a flexible tool such as this one is definitely an option. A further issue deserving attentive care is the use of commercial products. Authorities have temporarily found commercial devices acceptable given the importance of keeping the judicial machinery working during the health crisis. However, specific technological instruments conceived by a legal design task force are, in our view, recommended in order to fully comply with the right to a fair trial and the right to privacy. Right now, and I'm concluding, in the field of the digitalization of justice and of the multi-level protection of fundamental rights, there are important developments at the European stage. The EU Commission presented in December 2020 a survey on the e-Codex Toolbox regulation proposal with specific reference to possible developments in criminal proceedings through the exchange of information between courts in different member states. And in parallel, the new EPO, the European Public Prosecutor Office, is right now moving its first steps. This is a new approach to the multi-level protection of fundamental rights that, not by chance, is contemporary to the new EU communication to strengthen the Charter of Fundamental Rights adopted in December 2020 as well. Key is still the interstate cooperation. However, to exchange infos efficiently, there are many preconditions to be filled at the national level that will lead, if the e-Codex development will be approved, as it seems likely, to a more homogeneous national and European digital databases, and possibly legal procedures, even in the criminal field. I think I should stop now to leave more room to other panelists and eventually to further discussion with the public at the end of the round. I thank you.
Thank you. I give the floor to Aniel, actually continuing the same topic. Over to you, Aniel.
Yes, thank you, Gabor. First of all, I would like to thank EY for this invitation, for this interesting webinar we have on video conference hearing and fundamental rights. And of course, also thanks to ERA for publishing our article. In my presentation, I will have a focus more on the practical experiences in the judiciary in the Netherlands. So it will be focused from the point of view from the Netherlands. And I will talk in my second part more about some safeguards we need regarding to video conference hearings. As we all know, the COVID-19 outbreak has challenged long established legal procedures, at least the material functioning of the court and the rule of law itself. So video conferencing in court proceedings is seen not only as an exceptional measure, but also as a possibility for an effective part of the ordinary activity of courts. So fundamental rights are at stake, and of course the legal grounds we have to take into account are the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union, which accounts elements as the rights of defense, the right to have an effective remedy, the right to have a fair trial, the right to be heard, and the right to access a public hearing, and of course the right to protect your privacy rights. So as a starting point, whenever all the parties give their free and fully informed consent to the use of video conferencing in any given judicial proceeding, its use in such circumstances would appear not to give a rise to concerns under international human rights and to rule of law standards. In providing for an evaluating whether consent is freely given and fully informed, I think it's important that regard must be given to the particular situation, for example, of women's, children's, older persons, persons with disabilities, persons deprived of liberty, and others who may be in a situation where they may be forced or manipulated into providing consent that is not fully voluntary or informed. These conclusions were also recommendations of the International Group of Jurists, which they have published in November 2020. And I think that's an interesting starting point for this presentation. As we have a closer look on the situation in the Netherlands, I think it's important to have a close look on the several stages we have seen with the COVID-19 outbreak. In the first stage, which can be seen between 17 March 2020 until 11 May 2020, the courts in the Netherlands were closed. This was a decision which was taken by the judiciary itself, so it was not a governmental ruling on this. And it was also criticized by several members from the judiciary, saying that you cannot stop or delay the democratic society due to this COVID-19 pandemic which we were facing. So regarding to this first stage, there are two interesting rulings from the Council of States in which the question arose what the legal ground was to have a video conference when the courts are closed and when access to the court is not allowed for the public and when restrictions are taken by the courts. So the legal grounds were found in the European Convention on Human Rights and in the EU Charter. And I will illustrate this with these two judgments. These judgments can also be found in our ERA article, but I will highlight 2 points in this. First of all, there was the first judgment of the Council of State of 7 April 2020 regarding to the question what the right is to be heard at the court. It was a case in which a foreign national was waiting for his expulsion and he appealed regarding to the detention decision to the district court. Because of the COVID-19 measures, it was impossible to have physical hearing in that period. So the person was not heard in the appeal procedure, and instead his case was settled in a written procedure. So the question was whether the settling of the case in written violated the foreign national's right to be heard under Article 94 of the Aliens Act in the Netherlands and Article 5 of the European Convention on Human Rights. The Council of State concludes that refraining from a hearing of a foreign national, that is possible given the special circumstances of the COVID-19 crisis, but this cannot happen automatically. Every court in the Netherlands has to make a recognizable and individual assessment of all the interests involved. In this case, the foreign national lost his case, but for future cases, the Council of State acquired a case-by-case consideration and a justification why there was no physical hearing. The second judgment, it's related to the question of public disclosure of judgments. The second judgment of the Council of State concerned a ruling of a district court that was not made public through a so-called disclosure session, but was only sent to parties and made available online for other interested parties, because the court buildings were closed in that period due to the COVID-19 situation. The question arose whether this practice violated the principle of public disclosure of judgments. Now, the Council of State ruled that this practice is acceptable and does not undermine the essence of the principle of public justice, considering the current exceptional circumstances caused by the COVID-19 crisis. So I think these two judgments are an illustration of the first stage we have seen in the Netherlands. The judiciary took a lot of measures during the COVID-19 pandemic situation. After 11 May, and that's what we call the second stage in the Netherlands, courts were opening again, and we saw again physical hearings, which we didn't see for 2 months. I think it's important to note that in the period of 11 May until August of 2020, the courts again started with physical hearings, and in the courts we had some restrictions in that way that there were some restrictions in that people had to deal with the 1.5 meter distance standard, which was applied also in court hearings. From 17 August 2020, the presence of the public at physical hearings or judgments were allowed again. Interested parties had to register themselves by email to the relevant court to attend a court hearing or a public made judgment. And from 1 December 2020, we had some other restrictions. It was mandatory in the Netherlands to wear a non-medical nose and face mask in public indoor spaces. And the consequence was that in court buildings, everybody was faced with this restriction and was obligated to wear a face mask in the court building. In the court room itself, people were allowed to remove their face mask. In the Netherlands now, there is a temporary COVID Act, which gives the legal basis for video conference hearings in civil, administrative, and criminal cases. An interesting pending case at this moment at the Dutch Supreme Court is a tax case in which there is a fine against the litigant, who is a person who belongs to a risk group. He is 70 years of at least. He has medical problems and he was for a long period in hospital. The litigant was asked by the appeal court for a video conference hearing, and the litigant refused it because he wanted a physical hearing, because he did not have the equipment for a video conference hearing, and he was ill for a long period. In this case, the appeal court refused his objections and said that it was possible to do a telephone hearing. And this case is now pending at the Supreme Court, and the question is whether the appeal court could decide for a telephone hearing regarding to the specific situation of a person who belongs to a vulnerable group. Then I would like to make a step to some safeguards regarding to video conference hearings in which fundamental rights can be a problem. If we have a look on video conference hearings in criminal cases, there are some problematic issues which I would like to highlight and which could also be interesting for the discussion later. At any time that a video conference or similar technologies are used as a substitute for a physical presence, national authorities must ensure that any individual, party or accused that is deprived of liberty has access to legal counsel before, during, and after the hearings, including secure and confidential means of communication between the lawyer and the client. And there are, I think, 6 preconditions which I would like to highlight. First of all, ensuring that the ability of all persons deprived of liberty to have regular and confidential access to their legal counsel of choice is maintained despite any broader restrictions on visits to places of detention, including those arising from the COVID-19 pandemic itself. Second, equipping courts and detention facilities with rooms and means to enable counsel to confidentially communicate with their clients during the course of remote proceedings, whether when they are physically present or if they choose to communicate by other means. Thirdly, ensuring that litigants and others can be confident that authorities will fully respect the confidentiality of all such communications, including ensuring that such systems are not installed and operated by the state in a manner that could reasonably cause a person to doubt their confidentiality. Fourth, the individual party or accused can see witnesses providing testimony and can cross-examine and otherwise respond to them. Fifth, the accused or his lawyer can inspect or submit evidence during proceedings. And lastly, proceedings are suspended when interruptions in video communications occur and until they are resolved and technical support is available at the court and in detention facilities. I think another interesting aspect in this is the right to a lawyer. And in a number of cases where participation in hearings by video conferences had been found, there is case law of the European Court on Human Rights in which they found violations where insufficient attention was given to ensuring adequate confidential access of the accused or defendant to their lawyer before and during the hearing. For instance, I would like to refer to the 2010 Grand Chamber judgment and the subsequent 2018 regular chamber judgment in the case of Sahanovitsky versus Russia, and in 2016 in the judgment Gobernov and Gobarjev versus Russia, in which there was a violation found based on doubts about the privacy of a video conferencing system installed and operated by the state as the sole means permitted a person in remand prison to communicate with a lawyer for an appeal hearing. The court contrasted the case with an earlier case where there had been a separate direct phone connection between the person and his lawyer. As I'm looking at the time, I would like to make some concluding remarks. First of all, I think that the COVID-19 pandemic has delivered a progress for states to work with video conference hearings in practice. Legislation and court practices had to be changed. My personal experience in video conferencing hearings, which were related to social security cases, were positive, as I had experienced at least good technical facilities, which were working in a good way in a two-party dispute, in which the discussions and the legal discussions with parties were quite clear. So it was it were effective ways to do a court hearing, as we always did, in a physical way. Other advantages were for parties, at least, that they didn't have traveling moments. So it was, if we look in time, it was, I think, also an advantage for the parties that they did not have to make the traveling to the court in Rotterdam. However, from the judiciary point, I would say it takes more time for a judge to prepare a case. We have to check, of course, all the technical means if everything is working, and it takes more concentration for a judge, but also for all the parties who are involved in a video conference hearing. So in that way, video conference hearings are taking more time in general than a physical hearing at the court. In the Netherlands now, we have three types of hearings. First of all, we have the classic physical hearing at the court. Secondly, we have a hybrid hearing in which one of the parties is not available in the courtroom, and there is a technical line with that party who is not in the courtroom. And thirdly, we have the video conference hearing, which is a replacement fully of the physical hearing. In the COVID-19 period, the physical court hearings are different than before, as we have the 1.5 meter distance restriction. We have the obligation to wear a mouth mask in the court, and there are glasses between the judges if we sit in a panel of 3. It is important to point out that video conference hearings are delicate, at least in criminal cases or other cases related to punitive sanctions. I'm also thinking about asylum cases in which we have more parties, and at least the person itself needs, in most of the cases, translation, and other cases in which you are dealing with more than 2 parties. In these cases, there's a preference to have a physical hearing. In other cases, such as civil cases or administrative cases, a video conference hearing can be more suitable. Of course, we have to have a close look on the fundamental rights of Article 6 and 13 of the European Convention on Human Rights and Article 47 of the Charter, which are, I think, important safeguards to have a fair trial at the court. Finally, I would like to make the last statement that we have learned from the experiences of more than 1 year pandemic, and we have tried to find good solutions for the future. Therefore, sharing national case law and experiences from the different states are really important sources to realize that we can achieve this aim, as the rule of law is a fundamental aspect in a democratic society. This was my presentation, and I would like to thank you for the time.
Thank you very much. And we go over directly to the second presentation, the second topic, and afterwards we will hear the comments of Jan Petrov on both topics, followed by the discussion on, again, both topics. So the second presentation is broadening the scope of the investigation, namely the implementation of fundamental rights by courts beyond the COVID-19 situation to every other possibilities. The two presentators are Federica Casarosa, who will start, and Madalina Bianca. Both are related to the Center for Judicial Cooperation. Federica is a part-time professor here. Madalina is a researcher, coordinator of certain very important projects of the center. So Federica, the floor is yours.
Many thanks, Gabor. Can you hear me good? Yeah, good. Madalina and I will be presenting during this short time that allocated to us one of the results of the Center for Judicial Cooperation, meaning the output that has been organized and developed through the two projects that has been led by the Center for Judicial Cooperation in the past years. Because as Gabor was mentioning earlier, the center was built up in 2011, and most of the work that has been done through the center was through training projects and research projects. In particular, the training projects, the two that were the, let's say, the oldest one, were JUDCOP and Acciones, and they were the starting point for creation of an epistemic community where judges, lawyers, and academics started to speak to each other, but not just in a matter of having lectures or courses where the academics teach to the judges, but this was really a way to integrate and to share information, experiences, knowledge across the board. So making the opportunity not just for academics to teach to legal practitioners, but vice versa, to learn from the experience and to learn how the theoretical interpretation of rules and principles can work and be put in practice. And in this case, the starting point was the EU Charter of Fundamental Rights. But obviously, that was just the starting point. So in the book, we take advantage of all these experience and all the connection, the network of interested judges and lawyers and academics that participated in the project, and make the possibility to create a book that was based on this dialogue. So this was reflected in the structure of the book. And we have a lot of contributors, and I'm sorry that I will make sure that we will circulate at least the table of contents of the book, because there are so many that it's not possible to mention all of them, because we have judges that participated through contributions, through substantial contributions, such as Judge Nina Poltorak, Matteo Cetto, so also Raffaele Sabato. So just to mention a few of them, so judges that are part of the judicial community because they are constitutional judges, or judges at the European Court of Strasbourg and the General Court of the EU. So we have the opportunity to establish this, start this discussion on horizontal topics. So the main elements that are the horizontal clauses that are part of the Charter. And then we look at the selected areas, and we involved, in this case, also academics that address in particular the issues emerging from the application of the Charter in the migration and asylum area with Madalina and Judge Marc Clement, but also with taking also the lawyer's perspective. So we have Raluca Barcea that was commenting the one of the chapters of the book. And then we have a third part that is dedicated to the remedies and the part, so the violation, the application of the rules of the Charter related to the violation of the fundamental rights. And in this case, we address not only the, for instance, the issue of the nebis in idem with the contribution of Maria Bergström and Hans Sundberg, but also the issue related to the collective remedies. So we have a lot of issues and elements that are connected with the Charter, but we make also an effort to look at something further. Unfortunately, or luckily for us, the book project was developed before the emergence of the pandemic, so the spread of COVID-19. That was obviously an element that we took into account, but only in the process of drafting. But in this case, we have the, this is very interesting because the contribution of Pierpaolo and Aniel was clearly an element that could put a step forward in understanding how fundamental rights can be addressed in this different context. Our small contribution in this sense was dedicated to the analysis of judicial independence and the rule of law, for instance, but also in more general terms regarding the interplay between administrative and judicial proceedings and the ways in which the fair trial guarantees may be addressed in this context. So we have tried to enlarge the analysis and make sure that we do not only have the lenses of the EU Charter, but we move forward and to look at the more general perspective of fundamental rights. But one of the lenses that we used in order to address this evolution of the implementation of fundamental rights application was the judicial interaction techniques adopted by judges. And on this point, I leave the floor to Madalina, because I'm sure that she will clarify what this concept means in our book.
Thank you, Federica, and good afternoon, everyone. Thank you also, Gabor, for the introduction. And I'll just be very brief in providing a few clarification of what we mean by judicial interaction, because I think it's an important step that we deviated a little bit from the established literature in the field. Judicial dialogue has become quite a very popular term in legal literature. But at the same time, there is quite a huge critique, scholarly critique against the use of this term, at least in regards to the interaction between courts and judges. And several established authors have criticized it because it's rather a term that is more appropriate for the practice between political institutions. It is also very difficult to identify its form, be there implicit or explicit. And also, if we use the term dialogue, it means that there should be some ongoing exchange of ideas in judicial practice, whereas this is quite very difficult, and usually judicial practice is more often a sort of monologue rather than a dialogue. And so we didn't want to enter into such a minefield of scholarship, and we try to define our own term and to choose a term that is more broad and that could cover all the various instances of cross-references that we have observed, not only in these chapters, because as Federica has said, these chapters actually put down on paper years of interaction within seminars and training and exchanges, informal and informal, between judges and scholars. So we wanted to choose something that is definitely broader. And by judicial interaction, in a very basic level, we qualify a sort of sequel of judgment that refer to each other, involving at least two courts. And these do not necessarily have to be in a hierarchical relation, but what they do have to share is the intention of improving the practice of interpreting or reviewing a supranational norm. So in short, by judicial interaction, we refer to a set of techniques used by courts and judges to promote coherence and coordination, or at least to minimize the risk of conflicts among different legal and judicial systems in the safeguard of constitutional goods that are protected at various levels of governance. And in the introduction, and of course all the chapters of the book, they work with judicial interaction at three different dimensions. The engagements between domestic courts with the case law of the European Court of Justice and European Court of Human Rights is referred as vertical judicial interaction. Second, there are often interaction between judges within the same member state, and this we call horizontal judicial interaction. And third, national judges may engage with the case law of other member states' courts. And this type of interaction we call transnational judicial interaction. And this is also the form, the title or that we give to the interaction between the Court of Justice of the EU and the European Court of Human Rights. And as examples of judicial interaction techniques, we look at the duty of consistent interpretation of national law with EU legal obligations, as interpreted by the Court of Justice of the EU, the preliminary reference procedure, disapplication, comparative reasoning with national legislation and jurisprudence from other member states, mutual recognition of foreign judgments. And just to conclude, I thought it would be nice to share with you already some of the preliminary conclusions that come out of the chapters. Of course, I don't have time to do justice to all the variable nuances that we have observed, but I hope we will be able, as Federica said, to circulate a draft version of the introduction, and for sure this will also be published in a form of working paper for the Center for Judicial Cooperation. So in short, what we see is that although the Charter has been in force for a relatively short period of time, it has bolstered the judicial interaction between all European courts, including between the national apex courts and their European counterparts. And this is a very interesting conclusion, very nuanced, that has been emphasized and discussed in his chapter by Matea Ceto, who is a judge at the Constitutional Court of Slovenia. Also, the Charter seems to reach more and more fields that we have never thought they would be scrutinized for their compliance with the EU Charter. And for instance, the judicial organization, domestic judicial organization, taxation, criminal law, even consular affairs. Also, interestingly, the Charter plays a role in almost all the recent challenges faced by the EU. Migration, Brexit, for instance, on Brexit, we have Judge McCloskey, who deals with this perspective, rule of law as well. An interesting element and novelty that the Charter has brought is that of approximating EU norms to international human rights standards, and this is very much present in the field of non-discrimination. And for another contribution, which I have emphasized in my chapter, is that the Charter has also contributed to an incremental process of constitutionalization of rights at a domestic level. And for instance, it has helped to transform the interest of migrants into rights. Migrants, they don't usually have the right to vote. And so through the judicial interaction, their rights, their interests have been transformed into rights. But at the same time, there's a question that seems to come out from all of the chapters, and that is the boundaries of the EU Charter application, because this seems to be in a continuous development, and all the authors inquire how far can the Charter boundaries be stretched against national procedural autonomy. And to conclude, I would like to point out to interesting remark done by Judge Ceto in his chapter, who notes that we should also be very careful when interpreting the Charter jurisprudence, because many authors seem to overemphasize its relevance, when perhaps the effects of the Charter might rather be formal and symbolic instead of dramatic and direct. But nevertheless, like the common theme and at least the premises that we started at the beginning of this book seems to have confirmed, and that is that the Charter lives helped by the multi-layered judicial interaction, which seems to be growing and growing by the year. So thank you for your attention, and these were my very few points that I wanted to share with you.
Thank you very much, Madalena, and thank you for the presentations. Before we open the floor for comments and questions, let me give the floor to Jan Petrov, who is a researcher at Masaryk University's European Studies Institute, who will comment on both papers in a very short time frame. Jan, the floor is yours.
Thank you very much, Gabor, and good afternoon to everyone. And first of all, many thanks to the Center for Judicial Cooperation for organizing this event, which addresses such a crucial topic of these days. And I'm honored to have the opportunity to provide some broader ideas about the topic and reflect on the two great papers and presentations we have heard. And since both papers are already published or are to be published, I will try to provide perhaps a bit more broader reflections that will hopefully bring us to some more general questions in the discussion, where I believe the synergy and the meeting of the theoretical and practitioners' views are crucial. And the starting point and the common point of my intervention today is that the COVID-19 pandemic represents a critical juncture for the judiciary. And by a critical juncture, I mean a situation where the continuance of the old practices is unclear and where traditional interpretations might be called into question in order to find answers to new pressing problems. And in this context, I will focus on three main points. First, what should be the very role of courts during the COVID pandemic. Second, on the operation of courts. And third, on the question of judicial interactions in the context of rule of law backsliding exacerbated by the COVID-19 pandemic. So let me start with the first very general questions of what is the role of courts in the COVID-19 pandemic? Because if we have a look in the literature on emergency constitutionalism, which heavily builds on war and terrorism related emergencies, the scholars mostly focus on the executive, and with respect to courts, they suggest significant deference paid to the executive policies. But I wonder whether the very specific nature of this emergency, the fact that it's a global public health emergency, somehow should affect our thinking about the role of courts in this particular emergency. Because unlike in war and terrorism related emergencies, there is no clearly defined external enemy. There is no clearly defined group of evildoers that should be stopped. What we are facing is an invisible virus, which each of us could transmit actually. So we need a very thorough coordination measures and social distancing measures. So I wonder whether courts can help in this respect, and I think they play at least three very important roles in this context. So first, they can resolve individual disputes over emergency policies, because as we have all experienced, these emergency policies are very far-reaching in terms of human rights restrictions, and courts can contribute to resolving such disputes in an orderly way, which I believe is crucial in the highly polarized situation of protracted public health emergency. And second, I believe I can speak for most of us when I say that reading through the emergency regulations addressing the COVID restrictions was not the greatest rule of law experience of our lives. I think across countries, these emergency regulations have been very problematic, to put it mildly, from the viewpoint of legislative quality. So there were a lot of inconsistencies, unclear and undefined terms, constant changes, and so on, which is kind of understandable, perhaps, at least in the initial phase of the pandemic, but it also problematizes the very effectiveness of the executive emergency measures. But on the other hand, this is the day-to-day job of judges. Judges are the experts in interpreting law, and judges are the experts in overcoming these imperfections of legislation and executive lawmaking. So this is the second contribution of the judiciary, which I see, that judges can help to clarify this interpretation and increase the effectiveness of the emergency regulations. And third point, courts, I believe, play the crucial role of checking the executive and preventing the abuse of the emergency situation, because as we know, the states of emergencies usually aggrandize the power of the executives, and this is especially important in the case of the COVID-19 pandemic, which in many states led to partial closure or at least significant restrictions of the operation of legislatures, at least during the first wave. And I'm referring to legislatures here because parliaments are usually conceptualized as the major sites for scrutiny of the executive actions. So I see a very important role of courts here. So these are my arguments why courts can and should play very important roles in overcoming the pandemic. But the question is how they should operate, because judicial hearings require human contact, which increases the risk of transmitting the disease. So we need to look for some technical solutions how to make courts work, but minimize the risk of transmitting COVID-19. And the major solutions so far have been video conference hearings. And Pier Paolo and Aniel expressed so well in their paper and in their presentations the challenges with which this brings and the tensions with some human rights, especially right to privacy and a number of fair trial rights. And I think that they both did a great job in laying down the set of conditions under which it is possible from the viewpoint of European human rights law to conduct video conference hearings. And I believe that laying down this set of conditions is a contribution in itself, and I do not dare to contest this enterprise by Pier Paolo and Aniel in any way. Yet in line with my argument about COVID-19 as a critical juncture, I would like to propose a slightly different idea. And while Pier Paolo and Aniel in the paper show that under some conditions, video conferencing can be tolerated by human rights law, I wonder whether we can have a look at the issue also from the other side and ask whether a video conference hearing can, under some conditions, be actually required by human rights law. And I'm not saying that this is necessarily the state of the art in the European human rights jurisprudence, but let me just think about it for a while, because looking at the past events of the pandemic year, it seems to me that there's quite a significant overlap between the group most severely hit or endangered by the pandemic on the one hand, and by the most vulnerable groups in terms of human rights violations. And while the pandemic slowed down many things, it definitely didn't stop bad things and human rights violations from happening. So the judicial protection of human rights is at least of the same, and in many areas of law of even greater importance during the pandemic. And it seems to me that the means of video conferencing may represent one of the few possible ways how to provide effective and timely protection of vulnerable groups, human rights, while minimizing the risk of getting infected. And after all, it was the European Court of Human Rights itself who famously stated that the right to access to a court must be practical and effective. So I just wanted to ask Pier Paolo and Aniel, what do they think about this alternative view of the relationship between video conferencing and human rights, and whether they have encountered such cases in practice, such requirements by the parties. And the final third point concerns Madalina's and Federica's presentation on judicial interactions in Europe, and I would like to have a look on their argument in the specific context of the rule of law backsliding exacerbated by the COVID-19 pandemic. And as Madalina explained, together with Federica, they criticized the concept of judicial dialogue for being too vague and not too helpful. I believe rightly so, and therefore they suggest a concept of judicial interactions. And a definitional feature of their concept is, and I quote, a shared intention of improving the practice of interpreting or reviewing a supranational norm. And I believe that this presupposes a certain consensus on the values underpinning the given legal order. But as we know from the writings of Gabor and other scholars, the problem with authoritarian populism, which is usually seen as the engine of the rule of law backsliding, is that it challenges these fundamental values, and that it challenges some of the fundamental understanding of the legal concepts we use every day. So while I believe that the judicial interactions might continue even in the case of the backsliding countries and the captured courts, they might not necessarily be led by the good intentions mentioned by Federica and Madalina. And to provide a particular example, the Polish Constitutional Tribunal was deciding last year a case concerning judicial independence, and while it cited Article 6 of the European Convention, and while it referred to recent rulings of the Luxembourg Court on judicial independence, many Polish commentators actually argued that this interaction was not motivated by the good faith and the shared motivation of improving the concept, but rather to use it as a smokescreen against eventual criticism. So perhaps Michal, whom I can see in the audience, can give us greater details about the particular case and its context. But I just wanted to ask Federica and Madalina, since they brought together such a great number of great practitioners and scholars across countries and legal areas, whether they have encountered more cases like this, and how they deal with such cases in their conceptualization of judicial interactions. And I think I'll stop here so that we can have some discussion. So many thanks again to all the speakers and the organizers, and thank you for listening.
Thank you, Jan. Again, before opening the floor, let me give back the word to the presentators, because they were challenged by Jan in certain aspects, at least for a very short answers, if they feel fit to respond to Jan's points. But I will give you the floor anyway at the very end, because you may be challenged by other comments from the audience as well. So if you wish to react immediately now, this is the time for you.
Yes, Gabor. I really heard such interesting perspectives from Jan. So I'm a little bit curious and interested in further developments, of course. Maybe I leave to my fellow and friend Aniel a brief reasoning on this opposite perspective of how human rights law and EU law could forward the use of video conferencing, especially in immigration cases. Since Aniel is really an expert in this field, I'll just very briefly make a short consideration on the first question about the check on the executive powers and on the rule of law, if Aniel agrees. It's interesting that in the very first dramatic experience of the last spring, the condition was exactly that one that you pointed out. Many parliaments around many countries in Europe for weeks, for months sometimes, could not sit and work properly. This means that many governments could enact emergency regulation without any check from parliaments. This was the case, for instance, in Italy for more than 2 months. But many other countries experienced this condition. Then we saw the importance of constitutional courts and administrative high courts in making this check, this only possible check in a good and effective timing to the governmental action. So really, this is a reasoning that deserves further attention. Aniel, please.
Yes, thank you, Pier Paolo. I think Jan distillated, I think, 3 interesting roles he sees for the courts, which I can agree. So in that part, I agree with Jan and his and his reflections on the judiciary and which role they can play in the COVID-19 pandemic situation. Then Jan asked a question, and that's an interesting one, in how video conferencing, how that should be acquired by fundamental rights or by human rights, for example, for vulnerable groups. And I think, of course, for vulnerable groups, having access to video conference hearing, minimalizing, of course, their health risks is, of course, from a starting point, an interesting one. But I think we should also have, how do you call it, clear eye on the position of the vulnerable group itself. Because first of all, they should have access for a video conference hearing. They should be it should be accessible for them. So if you don't know how to work with it, if you don't have a computer, then there's already a problem with a video conference hearing. If we look, for example, to asylum cases where normally the asylum seeker is in a reception center, then the situation is already different. Then there will be access, or at least the immigration authorities can help that person to get access to a video conference hearing. But then the question is, with a translation, for example, it would be ideally that the translator will be in one room with the asylum seeker. If that's not possible, you can, of course, get a technical solution for it, that it will be translated from another facility room where the translator is, but that's already giving more difficulties for the asylum seeker. And then the question is, where is the lawyer? Will he be also in that same room, taking into account 1.5 meter distance? In some countries, it is 2 meters. Do you have to wear something or not? How, you know, how safe is it in that specific room? So those are some practical issues you have to take into account. So it would be difficult for me to say fundamental rights are acquiring a video conference, because then you have to provide at least some safeguards and also some restriction measures which already are issued by the member states. So I think with vulnerable groups, we have to be really careful when we are using video conference hearings. Of course, I say yes, it is possible, but we have to take into account some other measures. And it's interesting that tomorrow I have a meeting with the Dutch Advisory Committee. They are thinking also about asylum cases and video conference hearings instead of physical hearings. So there are some difficulties also in asylum cases due to questions as how to prove your identification if you don't have papers, how to deal with DNA tests, how do we do that in practical way. So these are, I think, some reflections I have regarding to this interesting question Jan has raised.
Thank you.
Thank you, Aniel. Federica and Madalena, I ask you whether you would like to react on this stage.
Yeah, just a very brief reaction to Ian's comment. Thanks a lot, and we will look forward to have additional comments also from the other participants. One of the issues that we would like to point out, and we will have one of the decision that you mentioned in your comment was exactly pointed out in one of the chapters of the book that was exactly looking at the development of the Polish jurisprudence regarding the independence of judges, and so how much the interplay between the decisions of the national Polish courts and the national legislator with vis-a-vis the decisions of the Court of Justice. So in this case, we have really pointed out, we have the contributors pointing out this problem, and the fact that in some cases the Charter of the Bench on the fair trial guarantees was clearly, as you said, only a reference and only a way in which they conceal how the real way of interpreting the national rules may change and may be reformulated in a different manner, because this is something that's really emerging from what is in a more general level what we call as an interconstitutional order, because we have in these in several chapters the reference to multi-level governance, where we have national constitutions, but also charters and Bill of Rights that are supranational, and their interplay is important in order to make sure that we have the effective safeguard of fundamental values. And as you mentioned, it's not easy to have a complete overlap, and the national interpretation of these values and may change, and the interplay between the two is not easy, and it's not achieving the improvement, an improvement and an harmonization in terms of implementation of fundamental rights. But this is really a challenge that is addressed in several areas, and the most important one, of course, is the ways in which constitutional courts have addressed the reference to the Charter and the ways in which they can be interpreted in the light of the EU Charter. But this is very short comment, and I hope that Madalena will follow up on this.
I'll be very brief because I see we're quite late. So first of all, thank you, Jan. I think this is precisely, it shows again the challenges of finding a definition that is accurate and that persists in time. Because we initially, and when I say initially, this is a discussion of 3-4 years ago, even more, I think it started right when the Center for Judicial Cooperation set its first activities 10 years ago. How do we actually define the interaction between courts in their judgments? And unfortunately, although we wanted to be as broad as possible to catch as many instances and forms, jurisprudence changes and then challenges us again. And this, coupled with the instrumental use of the charter, basically makes it very difficult to define something that is not that broad, that basically loses any meaning. What we try to do is to, let's say, the negative aspects or the drawbacks in our definition, to couple it with a little bit of more accurate methodology in the selection of cases. And as Federica has said, we thought that there will be instrumental use of the charter of the type that you mentioned in the rule of law, case law. So we asked the author, and in this case, very good chapter with really interesting insights from a Polish judge at first instance, who basically looked also at how the Polish Supreme Courts and Constitutional Court have changed their approach to the judicial interaction, and how a same or similar use, at least formal, in judgments is backed up by different objectives. So hopefully these nuances in the charter will put a bit more flesh and nuances also to our definition. But thank you very much, Jan, for this. It's definitely worth also including this in the introduction.
Thank you. So our time is very limited, but still I would like to open the floor for questions, comments may have arisen. So I ask all those who wants to raise questions to turn on their video, maybe introducing themselves very quickly and raising their hands electronically that I can see. By the way, I already asked the presentators beforehand whether they agree with the recording. So let me ask also those who do not want to be recorded, just mentioning that, and then we stop the recording. So who would like to raise questions, comments?
May I ask to Aniel and Paolo? Sorry, I couldn't find the raise my hand.
Participants, click to participants.
Okay, sorry. Okay, I will.
On the bottom. Okay, but we realize that you raised your hand, Federica.
Okay, sorry. It was just listening to your presentation and looking at the emergency reaction by courts regarding the fact that video conferences has been used as a way to solve a problem. So to react to litigation due to the pandemics. Do you think, in your experience, that it will be a tool that will be used also at the end of the pandemics? So looking forward to this period of time. But do you think that the use of video conference that was, as Pierpaolo was mentioning, not a new tool, but a tool that was already used? But do you think that in the future, given that we have this evaluation of the compliance of this type of tool in vis-a-vis the fair trial guarantees, it will be more used or will be more effective use, will be used in more effective ways in the procedures at national level?
Pier Paolo or Aniel, would you like to react?
Sure, Gabor. My view is that really this pandemic was a kind of revolution that will have long-lasting effects. I think that video conferencing before the pandemic had a very limited use, a very specific one, mostly in a few criminal proceedings and proceedings in family law. Now, it's likely that there will be a wider use, although there are still huge resistances among many practitioners, lawyers, and judges. We need, I think, to adapt to this new situation. One of the suggestions coming even from the reasoning of Jan was that there were many inconsistencies by the lawmakers because they were urged to do something in such a little span of time. This problem left many issues not solved. One of those is video conferencing. We need to think about this instrument not as an urgent and temporary instrument. We have to plan a more modern use of this technical device in both civil and so administrative as well, and criminal proceedings, I think. We need time to let things be clear, but I guess this is a new perspective, yes.
If I can give my expectations on this, I think in the future, I believe that video conferencing will be used more. And the reason is that we have made, or at least we have more experience than in the past. Well, we were urged because of this crisis, of course, and we had to deal with it. But I think these are, I think, positive elements of the crisis is that we have gained more experience, so we know the good things of it. So I do believe that we will use those positive aspects in the future, but I think that in the future, of course, physical hearings will be the general rule. And that will be, I think, how it will be done in the future. But I do believe more video hearings in the future due to this crisis, yes.
Thank you. Let me ask Michał Żulkowski, who is with us today and who was somehow challenged by Jan in his comments, whether he wants to react or it's no obligation whatsoever.
Thank you, Gabor. First of all, I have to stop my video because my internet connection is today extremely poor, so forgive me for that. And thank you, Jan, for your question. Can you hear me?
Yes.
Gabor, can you hear me?
Yes,
okay,
yes.
Great.
Yeah,
thank you, Jan, for your question. Okay, great. Indeed, last few years, we observed in Poland a new kind of judicial interactions. I would, and the example given by Jan is absolutely perfect. Generally, the abused, captured Constitutional Court started to interact with ECJ and European Court of Human Rights in a new, different way than the previous legal court did. For instance, the new captured court started to use what Barbara Grabowska-Moros from the Reconnect team once called abusive comparativism and abusive comparisons to justify the constitutionality of unconstitutional law. Then the court started to use ECJ judgment as pure ornaments with, in fact, it is sort of empty reference. And what is new, and what was pointed out by Jan, in a few judgments last year, the court started to use, I would call it, misleading citations to the European Court of Justice and European Court of Human Rights. Those citations are indeed sort of smoke screen, and they look like the following. First, the court put the citation to the European Court of Justice or European Court of Human Rights judgment. Then the court say that everything is in common and everything is okay in Poland. Then the court presents totally opposite interpretation of the constitution. So that is why it's completely misleading. And indeed, this approach was applied in the abortion judgment, very famous last year judgment of the captured court, and in the two judgments concerning the independence of the Supreme Court. So generally, it is a sort of a new interaction. And I'm wondering, because at the end of this month, we will have a next case before the captured court. This case will concern the constitutionality of the treaty, and the Polish Constitutional Court will assess Article 4 of the treaty. So we will see probably again, maybe developed even, that kind of abusive interactions with the ECJ case law. Thank you.
Thank you very much. Because we are running out of time, let me conclude this interesting conversation with not a concluding remark, but just a follow-up to Michal's last words. I'm afraid we are in a situation which is very unique in the European judicial practice, namely that it can happen in Poland that judges who are turning to the European Court of Justice with preliminary questions, they may be sanctioned in a criminal procedure, which is unprecedented, I guess, in the European Union. So I do not want to go further, but just to say that this underlines the importance of either judicial cooperation or interaction on different levels that Matalina has mentioned. Certainly a kind of solidarity by other national courts beyond the transnational courts are very much needed here. Those judges in Poland are European judges, at least at this moment they are. And that kind of cooperation and solidarity is in place. So thank you very much for all the presentators. Thank you very much to Jan for his excellent comments. And thank you for listening us. Let me draw your attention to the center next national training event in mid-June. The call for applications are already published. So I hope to see you all, or many of you, during those events, even if in a virtual mode. Thank you very much and all the best to you.
Thank you very much.